Welcome to a new episode of the podcast Immigration Law. I am attorney Fabio Losgerbo, and today we are discussing an important judgment delivered by the Regional Administrative Tribunal for Emilia Romagna, First Section, published on 27 February 2026, concerning case registered under General Register number 1845 of 2025. The case deals with a very practical issue that frequently arises in administrative practice. A foreign national lawfully enters Italy with a seasonal work visa, obtains the work authorization, signs the employment contract, submits the application for a seasonal residence permit, and undergoes fingerprinting. Everything is done correctly and in compliance with the law. However, the police headquarters does not proceed with the physical issuance of the residence permit, and after a significant lapse of time, formally archives the application. The administration justified its decision by stating that due to the short time frame between the administrative processing phase and the conclusion of the procedure, it had not been possible to proceed with printing the residence permit card. The tribunal rejected this reasoning in clear terms. It held that such motivation is entirely inadequate to justify the archiving of the application, since it is linked to a failure to process the administrative procedure in a timely manner, a failure that cannot operate to the detriment of the applicant. This is the core principle. If the delay is attributable to the administration, the foreign national cannot suffer the legal consequences. There is, however, an even more significant aspect. The failure to issue the seasonal residence permit directly affects the possibility of applying for its conversion into a standard subordinate employment permit. Without the physical residence permit, the applicant is placed in a situation of legal uncertainty. That uncertainty may reasonably affect the timely submission of an application for extension or conversion. The tribunal expressly acknowledged that the administration's delay may have been a determining factor, or at least a contributing cause, in the failure to submit a conversion request in time. At the same time, the judgment clarifies an important point. The conversion cannot be assessed ex officio by the police headquarters. The foreign worker must submit a specific application pursuant to Article 24, Paragraph 10 of Legislative Decree number 286 of 1998. But that step comes later. First, the administration must issue the seasonal residence permit that was lawfully requested. If no substantive grounds for refusal exist, the police headquarters must proceed with the material issuance of the permit, even if maintaining the original expiration date. The principle affirmed by the tribunal is straightforward yet fundamental. Administrative inefficiency cannot become an indirect sanction against a foreign national who has complied with all legal requirements. In immigration law, the difference between regularity and irregularity often depends on procedural conduct. Administrative legality is not a mere formality. It is the structural guarantee that rights and obligations are applied coherently and fairly. Thank you for listening, and I will speak to you in the next episode of Immigration Law.